I call the whistle roll.
Tēnā koe te mangai o te whare. It's my actual pleasure to speak on this Evidence Amendment Bill and this the second reading. Labor does support this bill. I am now a member of the Justice and Electoral Select Committee. However, I wasn't for the hearing of evidence related to this piece of legislation. I guess historically, Mr. Speaker, it's good to note that the Law Commission had been monitoring this Evidence Act since it came into force in 2006. And in 2007, the Law Commission was actually asked to review the law relating to the disclosure to criminal courts of evidence of defendants' previous convictions. And that was actually inspired by the acquittal of 2 former police officers on trial for sexual offending. So for the Houses and the people listening, that actually was part of the motivation for the review that the Law Commission then did. And it's interesting to note also that the Judiciary had their own Evidence Act committee that was monitoring its implementation. So in April 2012, the Law Commission invited comment and feedback on the operation of the Act from the public. And at that time, a group was established, an advisory group, which had as members Ministry of Justice, Crown Law, the Public Defence Service, the New Zealand Law Society and some academics. And so the purpose of this piece of legislation is as follows: admitting previous consistent statements, privilege for plea discussions, minor and technical amendments, restrictions on video record evidence. And I really want to focus my contribution this afternoon on 3 particular areas, and they are notice requirements for evidence of sexual history, presumption that child witnesses give evidence in alternative ways, and part of that is incorporates victims should never be the ones on trial, and also the ability now for a support person or more than one support person to support child witnesses when they give evidence. To the bill itself, and if we focus on Clause 16, which will insert a new Section 44A to provide for a process for giving notice where a party proposes to offer evidence or question a witness about the sexual experience of the complainant with a person other than the defendant. The interesting thing to note was that the intention of the bill is to encourage admissibility decisions before trial. And there was a submission of the judges of the district courts that actually has led to a stipulation about specified timeframes, which was a highlight in their submission. And so now there is a time frame. Clause 16, new section 44A5, to provide that application must be made when a case management memorandum or a trial call-over memorandum is filed under the Criminal Procedure Act 2011, subject to the judge's discretion. So I wanted to highlight that actually the Select Committee did do a great job, and they responded directly to the submission of the judges of the District Court. The other section or clause in the bill I'd like to highlight is Clause 25, which will amend Section 79, and that does provide support persons. So now there is a presumption that child witnesses, Mr. Speaker, will have somebody who will support them through that process. And there is also scope for more than one person to support children giving evidence. But there was also a clause added that was a suggestion of the Law Commission, and I want to highlight that. So it's 79(1)(3), and it reads, the judge may, in the interests of justice, direct that support may not be given to a complainant or a child witness or other witnesses by A, any person, or B, a particular person. And the Law Commission highlighted that there should still be scope in the process to ensure there isn't adverse influences on any witnesses. And so I want to commend the Select Committee for responding to that particular submission. I really, in terms of my substantive contribution, want to focus on Clause 32, but it's a replace Section 107. And this is about alternative ways of giving evidence by child witnesses in criminal proceedings. And what I was actually horrified to read was that there are 750 child witnesses every year, and that most of the complainants have faced sexual abuse. And that the intention of this piece of the legislation was so that children did not have to be in courts with their abusers. It was interesting to find out that a piece of research was undertaken in 2010, and it was titled "Child Witnesses in the New Zealand Criminal Courts: A Review of Practice and Implications for Policy." And so that was conducted by the Institute of Public Policy at AUT, and it was by Hannah, Davies, Henderson, Crothers and Rotherham, and it was funded by the Law Foundation of New Zealand with support from MSD, Justice and Police. And what the research essentially emphasised was that what sits behind our justice system and our court system is that everyone has the right to a fair trial. And the most accurate and complete testimony from witnesses were paramount. But also, there is a question of justice within our court system. And what it noted was that from the 1960s, New Zealand's treatment of child witnesses had been questioned. And so that was the motivation behind this piece of research. But what I found really interesting was that in terms of the now ability for video evidence, what it found that was during the 1990s, child witnesses were waiting up to 260 days before they were able to present evidence in court. At the time of writing this report, and I guess it would have been 2009-10, children were waiting up to 477 days. And so the ability for I guess some sort of contamination of the evidence, because they did a whole lot of other studies, but children's memories do become compromised because of the delays. And so what this this clause in the legislation allows is for the forensic interviews of those children to be played in court, and they are considered evidence in chief. And actually for me, that is one of the most significant changes in this piece of legislation, because what I found horrific, as I said, was 750 children who had been sexually abused having to give evidence in court with their abuser is now going to be rectified. I'd also like to highlight just a couple of other things, because in January 2016, Mr. Speaker, the Law Commission acknowledged that sexual violence was significantly underreported in New Zealand, and many victims fear how they will be treated in court. So what we're talking about is incredibly relevant, and I want to tautoko my colleague Jan Logie's earlier contribution, and actually I will be looking at those supplementary order papers. And this is what the President of the Law Commission said. A high percentage of victims of sexual violence are opting out of the very system that is designed to deliver them justice. They are doing so largely because they perceive the formal criminal justice system to be alienating, traumatising and unresponsive to their legitimate concerns. And what I found, I guess, frightening is that in 2014-15, only 19.2% of assaults actually got to court, but in 2015-16, that had decreased to 16.2%. So we actually do have a problem about the victims of sexual assault coming forward and wanting to give testimony in court. And the other point I wanted to highlight, and actually this is a bit of a wedal to our Minister, because I think she's doing a fantastic job. In December 2015, there was a recommendation by the Law Commission that a specialised sexual violence court be created. And I think a natural progression of this whole area, this kaupapa, is the establishment of that specialised sexual violence court. So I want her to know, I want the people of Aotearoa to know that this issue is one that is a priority and that we will all work on constructively. Kia ora.
Members.